Anytime you do business with a third party, you need to have a written agreement, especially if it involves trademarks, copyrights, or other intellectual property. I'm Angela Langlotz, trademark and copyright attorney, and I'm going to spend the next 3 minutes talking about this issue. So a guy calls me the other day. Most of my best stories start that way. A guy calls me the other day and he says, listen, so I have this problem. I was doing business with somebody else, and we had this deal where I was going to show them how to do what I do, and we were going to have this business venture together. We were going to split the proceeds, and I told him that he could use my trademark that was part of this deal. And I said, well, do you have the deal in writing? He said, no, I don't have anything in writing. And now this guy is like, he's broken our agreement. He's not paying me anything. And he's using my business model and my trademark. What should I do? And I said, well, it sounds like you've got a problem. Yes, we can stop him from using the trademark by sending him a cease and desist letter because he doesn't have what's called a trademark license. Anytime you let somebody else use your intellectual property, this guy had an actual trademark. Anytime you let somebody use your intellectual property, you need to have in writing what's called a license. A license is formal permission for somebody else to use your trademark, your copyrighted material, whatever it is that you want to give them permission to use under certain terms that you both agree to. When you do a business deal with somebody and you don't put the terms in writing, frequently what happens is things go awry. And since the agreement that you had with this third party isn't in writing, what happens is one party remembers it one way, the other party remembers it another way, and there's no document that everybody can point to and say, this was our agreement. This is what we both agreed to and physically signed to indicate our agreement to these terms. When you don't have a written document, you can't prove anything. You can't prove what we were doing or what you agreed to or how things were supposed to go down unless you have, for example, a long history of doing business together, and that's called, evidence that we had this certain course of business. Now, you can prove eventually, if you've been doing business together long enough, that this was your agreement because this is what we were doing before somebody broke the agreement, but it's always more difficult. And anytime your attorney says it's more difficult, you can translate that as more expensive. It's always more difficult to prove what the agreement was. You're going to have to bring in all sorts of other evidence, other witnesses. You're going to have to dig up extra paperwork. Why do that when, as an alternative, you could have a signed writing, point to the signed writing, and say, this is what we agreed to, right? Much easier. So please, folks, anytime you have a business agreement with a third party, I want you to do two things. Number one, go see a lawyer. Tell them what is proposed. Have that business agreement reduced to a writing, and then number two, sign the writing. And if you want changes to the agreement, put the changes in writing. Okay, that's number two. If you make changes, put the changes in writing. It's called an addendum to the agreement. Just because it's in writing doesn't mean it can't be changed. It just means that both parties need to agree to the changes. So please don't make business agreements or any type of agreement or licensing agreements for your intellectual property that are not in writing. The writing is intended to protect the reasonable expectations of both parties, and it's something that you can point to if ever there's a dispute about what was agreed to. I'm Angela Langlotz. I go live here on weekdays to talk trademarks and copyrights. You can find me online at TrademarkDoctor.net, on Facebook at facebook.com/TrademarkDoctor, and on YouTube just go to YouTube and search Trademark Doctor. I've got hundreds of videos there. If you have questions about trademark or copyright law, drop them in the comments below, and don't forget to like, subscribe, and share so that you can get my newest material that I put out every weekday.